avoid at all costs when you get your license.
Chapter 6.
Because you don't want to get involved in these type of situations. The criminal courts can punish a licensee, yes. Can punish a licensee by the state attorney filing a criminal charge. If the state attorney is the one that is going to go and file a criminal charge, not the commission. The commission or the department reports the licensees to the state attorney having jurisdiction. And they're the ones who will file a criminal charge and is successfully prosecuted. These are the criminal penalties. Practicing real estate without a proper license, third-degree felony, $5,000 fine, up to 5 years in prison. Rental list violation, we just talked about it. It's a $1,000 fine, up to 1 year in jail. It's considered to be a first-degree misdemeanor. These are the criminal violations of the 475 statute, and any other criminal violation is considered to be a second-degree misdemeanor, which is a $500 fine and up to 60 days. False advertising, misrepresentation, all these sort of things, filing false affidavits. Any criminal violation of 475, with the exception of the two, is considered to be a second-degree misdemeanor, a $500 fine, up to 60 days in jail. Question: licensee files a false affidavit to make a claim against the property. This will be a second-degree misdemeanor. Any violation other than the rental list rules and performing real estate without a proper license is considered to be a second-degree misdemeanor. Good. Civil penalties is where the public sues the licensee in civil court, and the court awarded judgment against the licensee. And judgment is in terms of dollars, and dollars are known as damages, either actual or punitive damages. These are what we call civil penalties, where the licensee got sued in civil court, and the court awarded damages against the licensee. They're called civil penalties. Question: broker is sued for misrepresentation. The court awards the buyer $100,000 in damages. This is a civil. Damages are civil. Fines are either criminal or administrative. Administrative penalties are administered by the Florida Real Estate Commission. When the commission invites us to go to Orlando, and they can reprimand us for something wrong that we did. They can issue a notice of non-compliance for a first-time violation. They can cite us monetarily, $100 to $500, $300. They can fine us up to $5,000 per offense. They can put us in probation, and they dictate the terms of the probation. They can suspend the license, maximum 10 years. They can revoke the license, that is permanent. And there's exception of fraudulent renewal, where they'll tell the licensee you can come back after 5 years and reapply. And finally, they can deny the application to get a license. These are what we call administrative penalties.
5 years, not here, right?
What's that?
What's set up with the 5 years?
Fraudulent renewal. Reapply after 5 years. The minimum time is 5 years for applying. Question: violation of Chapter 475 can cause it of the following. See, you guys are not reading the question. All it about. What is 475? It's a law. So if you break the law, can they take away your license? If you break the law, can they put you in jail? If you break the law, can they take away your money? Yeah. These are all 3 levels of penalty for the same violation. The commission takes away your license through revocation. The criminal court puts you in jail, that's imprisonment. And the civil court take away your money. These are all three levels of penalties for that one violation. They can sue you, they can put you in jail, and take away your license. What is the maximum time the license can be suspended on a first offense? 10 years. That's the maximum time they can suspend a license, 10 years.
Is there any minimum or?
10 years. And after 10 years, you can get back your license by meeting some of the requirements. Broker, who is temporarily incapacitated in regard to ability to act as a broker with safety to the public, will probably have his or her license to be a suspension. The key word there is temporarily incapacitated. They will not revoke the license, they will suspend the license until the broker is capable enough to continue practicing the service. It's called a suspension. So these are fraudulent activities. That means you can go to jail because the state attorney is going to file the criminal charge at the request of the department. Illegal commission, receiving compensation from other than the employer. You can take away your license and they take away your freedom. Overage, secret commission, licensee buying a client's property for resale at a higher price to a waiting buyer. It's called secret commission and overage. It's called unjust enrichment. Concealment, knew it but did not disclose. It's a violation of the agency law. You have to disclose all known facts that affect the value of the property that the buyer know about. Conversion, transferring someone's property to another use. Taking the money, broker took the money and spent it for their own personal use, called conversion.
One that says overage, say for example, you buy that property, not for to use, not for a waiting buyer. But say another year or two you have a buyer, that does not apply to you,
No.
right? You have to have a buyer waiting at the
Yep.
point in time when you do it.
Yep. A waiting buyer. Key word here is a waiting buyer. Culpable negligence, did not know but should have. That's like the broker who did not deposit the money in a timely manner. Or the sales associate who forgot to collect the additional deposit. That's also culpable negligence. Commingling, mixing the personal funds with monies to be held in trust, taking the money, putting and mixing with the broker's personal funds. It's called commingling, another illegal act. Failure to account, did not pay the money owed, like the two brokers. The one broker decided not to pay the other broker, or the broker decided not to pay you, the associate. It's called failure to account. Misrepresentation, it's a reckless or false statement, or omission of facts or misstatement of a factual matter. It's called misrepresentation. You're experts, therefore your words have consequences. So whatever you do or say, they must hold you to that higher level. And if you misrepresent, therefore they have issues against your license. Question, misstatement, omission, concealment of a factual matter is called misrepresentation. That's called misrepresentation. It's either fraudulent or negligent. Fraudulent means that they will criminal offense, a criminal act. Negligent means it's called culpable negligence. Florida Statute 475 allows us to give an opinion of value. We are allowed to do that under the 475 statute, but we are not allowed to give opinions of title. Giving an opinion of title is practicing law, and if we are doing that, it's called a third-degree felony. We cannot go there and practice law without having a law license. Just like you can't practice real estate services without having a license. So therefore, we can only advise the customers or our clients to go and seek legal counsel or purchase title insurance. We can elaborate. Elaboration is puffery. We can puff, not make me smoking some good stuff. We can say it's a nice house. It looks beautiful because beauty lies in the eyes of the beholder. In my eyes, I see value. In your eyes, you may see junk. Right? As you know, one man's junk is another man's treasure. Right? It's individual. That's called puffery. Exaggeration is somewhat different. Exaggeration is misrepresentation. I cannot say, well, you have waterfront property, and the waterfront is a retention pond. That's called total misrepresentation. Yeah, it's water, all right, it's waterfront. It's fronting your retention pond. That's called exaggeration. Yeah, it's water, all right, but the water is different. So my perception is you have waterfront. So, that's called misrepresentation or exaggeration. Broker listed property for 30,000. Broker learns of a new development which will be built beside the listed property. Broker purchases the property from the seller at the full list price and discloses the fact is a licensed broker. Broker then sells the property to the developer for 50,000. Which of the following is most correct? Yes. It's fraud. A fraudulent act called concealment. And this is where the broker is going to lose their money and lose their license at the same time. Because it's called overage or a secret commission. Then we come to the complaint process. One needs to know the 7 steps in the complaint process. You need to know what goes on in each step. They will test you what goes on in each step. So the first step is filing of the complaint. Who can file a complaint? Anyone. And this is really a question. Where does the complaint go to? We discussed it this morning, for those of you who can't remember. Where does the complaint go to? Looking at blank faces now. It goes to the department. The complaint goes to the department. And the department is the entity that will validate the complaint. Because the department is the one that issues or renews the license. So when the complaint gets to the department will have to look at the complaint to see if it's a violation of a law or a rule. There's only 2 laws and 2 rules. Department or commission rule, or the 455 or 475 statute. Then, if there's a violation of a rule or law, the complaint is declared legally sufficient. That's the standard. And once it's declared legally sufficient, it goes to the Division of Real Estate for investigation, because it's against real estate services. If it's for the CPA, it goes to the CPA division. If it's for nurses and barbers and masseuses, it goes to the profession division. If it's for general contractors, it goes to the general contractor division. So every division is responsible to investigate their own complaints. So if it has to do with real estate services, it goes to the Division of Real Estate and is given to an investigator. As you learned this morning, the DRE enforces the statute. Remember that? That's the commission enforcement arm. So they go out and start investigating, and they find that the complaint is of a minor nature. Let's see if you remember what we discussed this morning. If the complaint is of a minor nature, class, the department investigator is allowed to do what? To issue what in the field? Known as a citation. No? A notice of non-compliance. That is what they're empowered to do. To issue a notice of non-compliance. And when the broker or the licensee receive that notice, they have a timeline to correct the violation. Next exam question, what's the timeline? No, not 30. 15 days to correct the violation. And if they don't correct the violation in the 15 days, then the department investigator is allowed to do what after? Citation. The citation. And the citation is a ticket, monetary ticket, $100, $500, and must be paid or disputed within how many days? 30 days. And when the citation is not disputed within 30 days, what form the citation takes?
Final order.
Final order. Somebody already studied. It takes the form of a final order. It's final, it's gone. You pay it, not disputing it, comes final. So the department investigator says, well, the complaint is a little more serious, and what they'll do, they'll write the report. The report will contain their findings and their conclusions. They're not allowed to give recommendations or opinions. And that report goes to the Division of Real Estate Chief Attorney's Office. Whole bunch of attorneys there. They look at the report. They look at whatever the findings are, whatever the conclusions are, and they will make a recommendation. And that recommendation, along with the report, goes to the commission. And that's the first time the commission knows about a complaint. And there's only 2 commission members that know about it because they make up the probable cause panel. That's the only time the complaint is at the commission's level. On the first step, on the second step, the commission has no clue, nor does the public. Keep that in mind. The public has no clue that a complaint has been filed. The public is out of the business. They will know what happens. They just file a complaint, and it takes its course. The only people who will know that a complaint is there is the person the complaint is filed against and the person's broker, because the investigation starts. Because they go to the broker's office and ask for all those files and all this information to make sure that they do it properly. So once the probable cause panel gets the complaint and the investigation report and the recommendations of the chief attorney's office, they will decide what to do with the complaint. There are two members of the probable cause panel. One is a licensed member, one is a consumer member. And they will have to make a decision based on the reports they have in front of them. So there are three possible outcomes, and it's based on a majority vote. So there are two people, class. What's the majority of two? Gotta be two, right? So those two people have to decide one of three things. A majority vote, they will decide to dismiss. So two commissioners says, okay, we'll dismiss the complaint. That's one of the outcomes. The second outcome, if there's a tie vote, because you have two people, if there's a tie vote, it will be a dismissal. That is a default position. If there will be a dismissal, it's called a letter of guidance. A letter of guidance on the subject matter. That means they will tell the department to dismiss the complaint. And the department sends a letter to the licensee, telling the licensee the complaint is dismissed. Because there's a tie vote. And the default position is they will not go forward. Majority decides that the complaint is valid, then they will instruct the department to issue a formal complaint. And that's when the fourth step of the process takes hold. A formal complaint is issued by the department. The department takes the position of the public. Therefore, the department becomes the complainant, know the word. The department becomes the complainant. The licensee becomes the respondent. Is administrative law. Complainant, respondent. So, the complainant, department, files a complaint against the licensee. It's an outline of all the charges, and is sent to the licensee by certified mail to the licensee's known address. And when the licensee receives it, next exam question, the licensee has a timeline to reply to it. And if they don't reply to it within that timeline, their license will automatically be revoked. They will take it to the final order hearing and revoke the license. So what is the timeline, class, that the licensee has to reply to the complaint? 21 days. Know the timelines. 21 days. And they have to fill out that form called the election of rights form. So in the election of rights form, there's alternative how to handle the complaint. Well, there's only two choices the licensee has. Either to go to an informal hearing, take that trip to Orlando, and appear in front of the commission, final order panel, or challenge the complaint in front of an administrative law judge. Those are the two choices the licensee has in that election of rights form, other than not replying to the complaint and have the license revoked. So the licensee decides, okay, I'm going to take responsibility, and I'm going to go before the commission and that informal hearing process. So, licensee take a trip to Orlando. But before they want to take that trip, next exam question, they want to mitigate their penalties. And in order to mitigate their penalties, they will get in touch with the department's prosecutors and come to a formal agreement. And if they do come to a formal agreement, next exam question, what is the nature of that formal agreement? It's called a stipulation. Know the word? It's called a stipulation. A stipulation is a formal agreement between the licensee and the division's prosecutors what type of penalty they'll recommend for the commission's approval. It's called a stipulation. And it only occurs in the informal hearing process, where the licensee is going to take responsibility but want to basically negotiate a penalty, just like plea bargain. So, if a stipulation is agreed to, or not agreed to, the licensee takes that trip to Orlando, date and time, dictated by the invitation. That's what I mentioned, you don't want to get invitation. So they take that trip, and they appear in front of the commission's final order panel, called the final order panel, made up of 5 commission members. The 2 that serve on the probable cause panel, they will recuse themselves. The 5 remaining members will decide on the licensee's fate, and it's based on a majority vote. And if there's a stipulation, they will vote on the stipulation. And when they do vote, and the majority rules, that becomes a final order. And that final order takes effect within how many days? How many days? 30 days. 30 days from the hearing, that final order takes effect. 30 days. 30 days from the time it was agreed to by the commission. Licensee going to challenge the complaint. It's going to go before an administrative law judge who's going to convene a hearing. So the prosecutors from the DRE and the licensee appears before the administrative law judge. It's have quasi-judicial powers. And the judge basically is going to listen to both sides of the evidence. And when the judge hears all the evidence, the judge will issue an order. What is the nature of the order? Class next exam question, the administrative law judge is going to issue in this complaint process. It's called a? Nope. Wow. It's called a recommended order. You guys read the book, right? No? It's called it's called a recommended order. That's all the judge can do, recommend. They just can't place a final order. The only person who can place a final order is no. It's only for one, the commission. Commission is the only entity can place a final order in this circumstances. The judge can only recommend in this instance. And that recommended order goes to all parties, including the commission. And the commission convenes a final order panel again. And what they can do with that order? They can modify it, they can reject it, or they can accept it. Because they have the power to do so. And what power do they have, class, we discussed this morning, for them to do that? It's called quasi-judicial. Called quasi-judicial. We discussed that this morning, didn't we? I sent you guys to lunch and dementia problems. It's called quasi-judicial. Citation, yes. Final order commission issue it in a complaint process when there's an investigation. That has nothing to do with that. Has nothing to do with that part. This is into the complaint process. Yeah. Yes. So, final order, based on majority vote of the final order panel, becomes final in 30 days. So if the commission's final order decides to let the licensee's license get revoked, the licensee can still continue to practice within those 30 days. And the public will be at risk. Because the licensee has nothing to, hey, I got my license revoked in 30 days, who cares now? I'm the most dangerous person in the field. So in order to protect the public's interest, class, next exam question, what does the department do to protect the public's interest when there's a final order for revocation and it takes effect within 30 days? Very good. The department steps forward and issue a summary suspension of the licensee's license. That means the licensee is out of business immediately. And if you start practicing, it's considered to be a felony. So it's called a summary or emergency suspension, and it's issued by the department's secretary or their official designee. That's what the department does to protect the public's interests. Because the department issues a license, and they have the power to summary suspend it for a period of time until the commission final order kicks in 30 days.
Can I ask you a question?
Go ahead.
You decide to go to an informal hearing,
Yes.
but then you don't like the end result.
No.
And you change back to a
No,
formal?
you're done.
So you're done.
You're done, you can't go change your mind, yes. It's like a plea bargain. When you plea bargain,
But a plea bargain, you know what you're getting though.
yeah, but you know, you get, but in formal hearing, you go before the judge. Right, and you said, okay, I'm here. If you decide to basically object on the hearing, then you stop the hearing.
Well,
And
that's
it's
what I'm
another-
saying.
yeah.
If I go to informal and I don't like what they're giving me.
No, not what I'm giving you, is when you go into, basically, in the formal hearing, you have to stand there and take responsibility. And if you said, no, I didn't do that part, they'll stop the hearing completely. And say, go to a formal hearing. Because they'll read out all the charges. Did you do this? Yes. Did you do this? Yes. Did you do this? Yes. Did you, oh no, I didn't do that part.
Before they tell you what they're gonna do.
No, they don't tell you, not before they tell you. You have to accept total responsibility before they issue that penalty. Now when they issue penalty, hey, I don't like your penalty, I'm gonna go, no. No. You have to say yes to everything. And the minute you say no to one of those charges, they will stop the hearing.
Yeah, but the plea bargain is different.
That's how you-
Yeah, plea bargain, you tell me what you're gonna give me.
That's
I
right,
don't
that's
give
why you go,
And then I
for
say,
the stipulation, if you can negotiate stipulation, not if you be successful. They will have a stipulation in certain cases. Go ahead.
Does the person who filed the complaint initially know any of these
No.
things that are going on?
No,
When-
unless they come to the, when they were advised that the hearing is been called. Because department takes the position of the public now, not you the individual. Department is the one who basically is gonna take the position of the public.
Would they know the outcome though?
Yeah, they know the outcome, it's gonna become public.